Okay, so the next item up on the agenda is the transfer on death of an interest in a stock co-op, memorandum 2020-56. At the last meeting, we talked about execution and revocation formalities. And I indicated that I had made inquiries about what role title records and title insurance play in the transfer of an interest in a stock co-op. I had a lead with some folks who do a lot of escrow work in Rossmore, where there are significant number.
His Wi-Fi's off. Oh,
What happened to Brian?
he's free. He froze.
It's cold out.
Yeah, and then I'm going to take the moment, just Linda, I guess you're Linda Brown, and is there anyone else on the attendees for this topic? Can you show by hands? Okay, great. Thank you. Perfect. Brian. Oh,
You got me?
there you are now.
Yeah, okay, sorry, I dropped. It's been a little unstable the last few days. All right, I'll cut to the chase. I repurposed this memo and made it a vehicle for a number of little nuts and bolts issues about rules that are in the revocable transfer on death deed statute that I think would also be either appropriate or inappropriate for stock co-ops. And the whole thing, the issues I selected to be non-controversial, pretty straightforward and obvious. And so I framed the whole thing as a presumed consent. And so there's an opportunity for commissioners who have questions or concerns about any of the issues described in the memo. But if there are no such concerns, then you could vote approval of all of the proposals in the memo as a group. Does anyone want to talk about it?
I'll recommend approval as proposed.
You're muted, Crystal.
I asked while you were frozen if there were people that wanted to comment from the audience on
I'm
this.
giving you a second to Rick's motion.
Let's see, I think I've got a hand from.
Yeah, there's
Nope.
Catalina, and then also Linda had raised their hand.
Well, I'm not showing them. Are those folks still interested?
Oh, you know what? They removed it, so maybe they're not interested. And because we're going to approve it, then I guess that might have addressed it. We might as well take a vote, even though I'm just assuming. So I heard a second to approve the motion.
Yes, I gave you a second.
Okay, good. And so all those in favor say aye.
Aye.
Okay, so there are no abstentions and no nays, so it's approved.
Good, very efficient.
We can go to the next.
Yeah.
Memo. Let's see. Next memo then is the recodification of toxic substances with Kristen.
Yep, that's mine.
There you go.
So I'll be presenting on memorandum 2020-62 and it's for supplement. I'm going to start with the main memo and then we'll get to the supplement after that. So the memorandum starts the discussion about the different issues that need to be addressed so that the commission can finalize its recommendations, recodifying chapter 6.8 of division 20 of the Health and Safety Code, and then making all the necessary conforming revisions to reflect that recodification. So the memo starts with some general background because it kind of helps to ground the commission in what the posture we're taking to address the different comments that came in is. This study, we have limited authority. We are not supposed to make any substantive changes. And because of that, we've been very careful and reluctant to change the existing language. We've set a very high bar for ourselves in terms of when we might consider making those changes. And essentially the guiding principles that the commission adopted early on in this study set a very deferential posture to concerns about our proposed restatements. So where there's a proposed change that we were going to make and someone comments and raises concerns, we've often just recommended backing that change out, reverting to existing language. These are pretty standard policies that we've adopted for recodifications, and they're what we've used here, and they're what actually kind of settles a lot of the issues that are presented in this memo. And for that reason, we've used proposed consent to address those items that seemed like they were non-controversial changes that were dictated by these guiding principles, or that just seemed very straightforward. So one of the biggest issues that the commission has to address is, how are we going to address all of the different notes that we've included in our tentative recommendation? We used notes where the commission saw some potential problem or just wanted to explain a change that they made. There were a number of different notes that we put into the tentative recommendation to either call for comment or just make an explanation. Over 200, and many of those notes did not get any comment. So now we're left with questions about where we put in a note, there was no comment, what does the commission want to do? Typically, we've sort of set up categories of notes. The informational notes, typically those just explain some adjustments or restatements that the commission made. If no comment was received raising concerns, we'll just continue the provision as it was presented in the tentative recommendation. The other types of notes are a little bit more complicated. In some cases, we identified what we called an apparent error, typically a broken cross-reference. In those cases, we actually have to make a change regardless of whether or not there's comment. And so those issues we'll be discussing in the memos and figuring out how to fix. But there's two categories where it's a little bit less clear what the commission might want to do. And those are notes where we flagged a potential problem, where it seemed like maybe there was something wrong here, or maybe this provision could be improved in some way, but it wasn't really clear. There's actually quite a few of those. The exhibit, the 4-page exhibit attached to the memo, offers the commission the option of adding all of those different possible problems to the list of issues for possible future study. And that list is something that is required by the assignment to the commission. We have to have a list. But one of the, I think, complications that we realized in preparing for today was how we should think about that list, what that list should represent. And this kind of gets to the bigger discussion about the commission authority that's sort of been a theme running through this meeting. Previously, we had been thinking about kind of keeping the list relatively small because we were kind of envisioning it as almost a to-do list for the commission, that the commission would be setting itself up for working on these topics going forward. For that reason, the staff was definitely a little reluctant to add, a 4-page bulleted list of items to the commission's to-do list. Right now, we're not even in the middle of this study. We still have more than half of the work left to go. And, that would just be a sort of huge undertaking to address dozens and dozens of different items. Now, the issue is we don't really need to consider the list to be a to-do list for the commission. The list could simply be items that we've uncovered in the course of our study that could justify future work from the commission or from someone else. And so we would treat it as a more comprehensive list, just to flag things that we've seen as we worked through this that we might ask for some authority ourselves to address. Some, but the idea is that we probably will not address them all, and we would want to make that clear. So the big question for the commission, this memo actually was drafted when the staff sort of had a more curated, limited list in mind. And for that reason, some of the recommendations that we made were geared towards a list that was meant to be narrower and specific and almost serve as a to-do list for the commission. Now, if the commission doesn't want to try to craft a list in that way and thinks that it should just simply identify the things that we've seen, that would be something that would the staff would really appreciate a decision on, because that would help as we move forward figuring out what to do. And it might make the decision about whether or not we want to add certain things to the list much easier. So I guess I just want to ask the commission is, how do you want this list crafted? Do you want it to be a more limited, curated list, or a more comprehensive list of the things we've come across in this study. Any comments from the commissioners?
No, any comments? How do you guys feel? Jane?
I'm sorry, I like mute, unmute. I think that maybe it would be more effective to be a more curated list. I mean, I'm not opposed to it either way. I'm just trying to think in terms of the work that you've done. What, in your personal opinion, Kristen, is there, do you feel an approach in terms of being able to present the information in a way that would be most accessible and most effective would be to curate it and have it as a specific list of items instead of, this overwhelming sort of grocery list? I'd be curious how you feel about it.
I think one challenges is, in the absence of public comment, sort of critical and key issues are to put on the list. We identified dozens and dozens of items where we thought maybe there would be a problem, but we're not sure without having more comment from people who are more familiar with this law in practice. And without that comment, it's really hard for us to make a call about what should happen in those cases. And so I think that's sort of pushing staff more towards the idea of a comprehensive list, because that way, as we move forward, we can sort of pick and choose and find the low-hanging fruit and address those, but step back from the things that aren't causing as many problems in practice. Some of the law actually seems to be kind of dormant for now, and in those cases, trying to make improvements in those areas is probably not going to be that helpful. But it's a little hard to assess that from where we're sitting.
Well, that makes absolute sense to me. And I think that's along the lines of what I was thinking if some things weren't. So maybe the point is to have the comprehensive list and then, be very proactive about trying to get as much comment or input from agencies or individuals so that then shows us what would be the most effective way to proceed. Thank you. That was very helpful.
Yeah, and I think just to go along with that, to the extent the commission wants to make a more comprehensive list, we would definitely want to sort of craft the provision that would authorize the commission to work on these things to make clear that we do not plan on undertaking all of these things. And in fact, some of these things may not really be suitable for commission work at all, and we may know that now. But we don't want to commit ourselves one way or the other to addressing these items, because in some cases it may not be useful, or we just may not be the right entity to do it.
I think that makes sense. So then the plan would be, Kristen, to take your list and then to go ahead and start asking for public comment, or because you have uncovered
Well, so I think we
all these issues. There, I hear you.
Yeah, so I think we would sort of build the list. We'd probably add most of the things that we've flagged for potentially adding. We might circle back with DTSC and see if there's additional things that they see that needed to be added.
Could I interject briefly? First, a couple of things. First, are other people experiencing Zoom connectivity problems?
Yeah.
Is it universal or is it just me?
Yes.
I just got a note saying mine was unstable too. Someone told me that once you go over 40 minutes, then that's when things start getting
Oh,
haywire.
we don't have that problem because we got a super user account.
Yeah,
Okay.
my connection's fine.
Okay,
My connection's fine, but there's this funky thing that happens when you try to talk. Customer does this thing.
oh, I heard that too, yeah. Okay, that's kind of what I was getting at. So maybe Kristen's connection is sketchy.
I did get a note that it was unstable at one point, but it seems
Yeah.
to have kind of evened out.
Okay.
I got a note saying mine was unstable too. And then Brian, you were freezing too. It might, but that's hopefully right now we're doing
Yeah.
fine right now.
Yeah. The second point I wanted to interject is that in the substance of what Kristen's talking about, I think it might be helpful to give an example of what caused us to rethink this. There are some things that we look at them and we think, this is a problem or potentially a problem that needs further attention, but we aren't necessarily the right ones to do it. And so then the question is, do we put that on the list or not? You know, is it a list of problems, or is it a list of problems the commission's going to work on? And the example I have in mind is there's a provision that has to do with military base closures from the 90s. And it creates certain kind of limitation on DTSC's ability to hire and fire people who were hired to manage the base closure process. So it's like locking in certain personnel and immunizing them from agency control to some extent. And DTSC, I think, correctly commented to Kristen that, like, well, you know, it'd be helpful to reevaluate whether those positions are still needed, because the base closure process, a lot of that's done. And so we've got these staff that are locked in to do that, and maybe we don't need them anymore. And I think that's an example of something where the law might be sort of functionally obsolete, but I really don't see the commission being the one to evaluate personnel issues and spending, et cetera, et cetera. That's something for DTSC to work out with finance and with the relevant legislative committees. So the question, it sounds like the commission was moving towards this list being a list of problems, a more comprehensive list of problems, without necessarily any kind of obligation that the commission is the right one to fix them. And I think that that's the example of what caused Kristen to sort of reevaluate the function of the list. So I'm backing out now. I just thought it might be helpful to have that concrete example of where this discussion's coming from.
Yeah, so I also just wanted to tag on to that. I mean, one of the other things is I personally was very concerned about the number of items that are in the exhibit, and sort of adding that to something the commission would be committing to work on without having gotten even halfway through our original assignment seemed like a lot. So if the commission wants to move forward with a more comprehensive list, I think it makes sense that we just include everything we find and, you know, consider at a future date what sort of things that we want to try to pick off and address. And that seems to be the sense of the commission, is that right? Okay.
Well,
Right.
I'm thinking that you can narrow it down even more though, and just work with a curated list so that of key topics, Kristen, so that you're not having to document everything that comes up. That sounds like that's overwhelming too.
Well, I mean, at this point, we've got a pretty good list of the things that have come up for us, and there haven't been a lot of comments that have come in across time.
Okay.
Most of the comments have come in at the end, and I've been, working through those. So I will, keep that in mind as I'm moving forward, and just where there are things that need to be cataloged, we can add them to the catalog.
Yeah, that's good. And then just for the other commissioners, because do you have a deadline on when you're supposed to be done with this study?
So there is not a strict deadline on this study, but one of the things we often work towards is trying to kind of get these things wrapped up by the end of the year, in the hopes that we might be able to do legislation the following year. That is a possibility, and we are working towards that. There's still a lot of outstanding issues, so I'm not sure whether we'll get there, but we might. So,
okay. All right. So I think everyone is in agreement that you're going to go ahead and proceed with the list that you have now, and then just try to wholesale complete your project or complete the study. Commissioner Rubin, you're in the dark a little bit right now. I know that you said that you weren't going to be able to be on the call for the entire time.
No, I'm still involved. I'm going to get off shortly, but I was in the dark. Sorry.
No, it's okay. I was just checking in with you. All right. Well, then let's go to the next study. Oh, good, Rick.
Yeah. Is it okay to make a comment on one of the specific things within the document?
sure.
So proposed section 68-200, which is the bottom of page 15, top of page 16, about the Director of Finance scheduling certain things in the Annual Budget Act.
Yes.
I'm okay with the structure that the DTSC prefers, which is current law, except that, in my view, current law is unconstitutional.
Okay.
There is no annual budget act until the legislature passes a budget bill and the governor signs it. Then there is an annual budget act. Director of Finance has no authority to change the annual, to do something to the annual budget act. That's a statute. Director of Finance has no authority as the executive branch to change the statute. Director of Finance has no authority to change the budget bill, but the Director of Finance does have the authority through the governor to put something in the governor's proposed budget, which is also required by the Constitution by Jan 10. So
Okay.
my suggestion would be that whichever way you end up structuring it, it ought to say the Director of Finance shall schedule in the governor's proposed budget the project's proposed blah, 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 blah. Because as even current law is unconstitutional. And I would turn to my consigliere, Mr. Carrillo to.
Did somebody mention the California Constitution?
Yes.
Rick is right, of course.
So in this case, there is a question as to whether or not the commission wants to try to resolve those issues now or address that as a matter for future work. So does the commission have a preference as to how we address that? And if so, if you want to address it this time, I think we would probably craft proposed language and bring it back to make sure that.
I would do that.
Okay.
I'm just thinking just for maybe let her finish or let her get through, and then maybe in the beginning of next, when we meet in January,
That's fine.
kind of just touch base with what issues are there.
Yeah, so that I will take off and I'll look back at that with that in mind and how we need to redraft that to address that issue. So.
And then you had a supplement, yeah.
Yeah, well, there's still several items. So there are a number of issues that affect multiple provisions. In that case, all of those issues are proposed consent items, and I wasn't planning on discussing those. But there are some individual issues that the memo discusses that actually do need the commission decision. And one of those is proposed section 68020, and that's on page 12 of the memo. This is one of the commission's general rules of construction that helps to explain the effect of judicial decisions interpreting prior law. The commission got a comment from DTSC raising concerns that it seemed a little bit complicated. The provision was kind of complex and that it could be simplified, and they actually made a suggestion as to how to simplify that. The staff is concerned that the proposal that they made doesn't address all of the issues that the commission's proposed language does. And the commission has been uniformly using this language in its recent restatements, and the staff sees value in retaining the uniform language. So that's the staff's recommendation, to stick with the language. It's in the tentative recommendation. Is that okay with the commission?
Yes. Are you
Okay.
guys in favor? Yeah, everyone is. Yeah, plus you're not done. So we can, it's okay. Just stick with your plan.
We're getting close, though. We're getting close.
No, I mean, I'm just saying for them to take issue with how I get it. They want to just, you're going to note it and you'll be able to get back to it. Okay.
Yeah. And yeah, we are still working with them. I am still in contact with them and trying to get additional information to resolve a few outstanding issues. So I will be in touch with them. The next item is proposed section 68105. It's the definition for a release of hazardous substances. So in this case, the existing law has the definition in two parts. So one section has the things that are included and the other section has the things that are excluded. We've combined those into a single section and we've made some structural changes for readability. And DTSC pointed out, well, DTSC was generally in favor of combining the sections, but pointed out that structurally now there's some non-parallelism in the different exclusions. And so there's some proposed language that would resolve their concern that is offered in the memo. I guess perhaps I shouldn't call it proposed language. The staff didn't make a recommendation on this topic because originally the language in the tentative recommendation is actually closer to existing law. And so there's kind of a thumb on the scale in favor of staying close to existing law But in this case, the staff didn't see any problems with the revised language that we offered, and it would seem to address DTSC's concern. So the question for the commission is, do you want to adopt that revised language for that section?
I'm looking at everyone. Okay, thumbs up.
In favor?
Go
Okay.
with Kristen's. Okay, good.
And so actually the last issue is one that was already raised by Brian, which is the proposed section 68210 that deals with the sort of protected positions related to military base closures. Given the decision about the list, we would sort of reverse what was in the memo, the staff recommendation there, and just suggest that we put it on the list because we're going to be doing a more comprehensive list.
Yep.
So
Yep.
that seems like everybody's okay with that?
Yes.
Okay, and the last thing is just getting a vote on the consent items in the main memo. I will take the 68200 off of that list, and with the idea that I'll be bringing that back for the commission. But otherwise, are the consent items acceptable to the commissioners? Good.
Victor, are we going too fast? Okay, good. You go. Okay, good.
And the last thing is the supplement. So the supplement discusses a provision of Chapter 6.8 that relates to a specific site, the Santa Susana Field Laboratory. That site is located down in Southern California. The memo gives some context to sort of help ground it a little bit about what this controversy was all about. Essentially, the key point is the federal government had responsibility for cleaning up radioactive materials, while the state government had responsibility for cleaning up the chemical contamination. And there's been some friction there, I think. And in 2007, the legislature enacted a section that applied specifically to that site and purported to give the department authority, decision-making authority about whether or not the site was clean enough for both chemical contamination and radioactive contamination. That law was challenged. It went up to the Ninth Circuit. The Ninth Circuit said, you know, this violates the supremacy clause. The law is invalid. It's not severable. And so for that reason, you know, that law stayed on the books. No changes were made. But the question for the commission is, what, if anything, do we want to do about that provision in our recodification? So typically that's not an issue that the commission would address individually in its recodification. As the supplement explains, we enact some general rules of construction about how the judicial decisions interpreting former law should apply to the recodified law, and we leave it at that. In this case, you know, we got comment that it's a little bit confusing. I think if you look at just the reenactment of this provision out of context, it seems very strange that we're taking a law that's been declared invalid by the Ninth Circuit, breaking it into pieces and kind of like cleaning it up and making it look nicer. Given that, the commission may want to consider helping provide, you know, some more, I guess, keeping the law more similar to how it is today, to avoid sort of making the implication that our organizational changes should be construed in some substantive way. So one option that the memo presents is just, does the commission just want to recombine this section and kind of leave it alone, silo it and avoid making any adjustments? One of the other possibilities that the memo presents is the possibility of a comment. Now, this is something the commission has considered in the past for different recodifications and declined to do. One of the problems here is that the commission's comments are evidence of legislative intent. So making decisions just based on what we know and what we don't know, without being really comprehensive and making sure we're doing it consistently, can lead to some problematic implications. And for that reason, the staff recommends against putting any information about in the comment for this specific provision or pointing to a specific case. You know, if there was another case out there that we weren't aware of and we didn't note that, I think that might lead to some questions about, well, what does it mean? And are you endorsing this particular decision and not this one? And how should we think of that? And the final item that's offered is, you know, whether or not this should be on the list, whether or not repeal or replacement amendment of this section should be considered based on the Ninth Circuit decision. And we're looking for guidance from the commission on what, if anything, they want to do with this provision. At this point, it doesn't seem like there's a legal problem. Our general rules of construction resolve that. But I think there might be a perception problem if we are sort of breaking this existing section up and recodifying it as if it's just like anything else.
Yep. Go ahead, Rick.
That was kind of my concern. I mean, it kind of looks like we're just, you know, structuring it differently, but reenacting a statute that has been declared unconstitutional by the Ninth Circuit and basically sort of flipping them off. My inclination would be, don't touch it, put it on the substantive list to, you know, basically ask the legislature, do you want to leave this on the books? Do you want to repeal it? Do you want to reenact it in a different form? Although it sounds like the different form would still have the constitutional problem that the Ninth Circuit identified. So yeah. It seems to me like we ought to put it on the list for somebody else to look at.
Or silo it. Yeah, that silo idea is
Siloizing. I didn't know it was a verb, but.
So it seems like we could just leave it as is, add it to the list and take a more
Don't
hands-off approach.
Yeah.
You
You guys you're in agreement? Yeah.
Okay,
Okay.
that sounds good. And I think that's all I've got for
did
today.
good.
So thank you, commissioners. And I'll be bringing back more of the comments and issues in the tentative recommendation in a future memo.
Cool.
Very good. I'm like looking for my agenda now that I just got rid of. Let's see. But I think it brings us to the last item, which I was concerned because I wanted to make sure we had enough time and we have attendees. So,
No,
Barbara?
no, we've.
oh, yours is the court. Okay, I'm sorry.
Yeah,
Barbara, go
yeah,
ahead.
we've still got the trial court restructuring memo.
Yeah, no.
That's memo 2020-63. And basically in 2001, long ago, when the commission first started cleaning up the codes to reflect trial court restructuring at the direction of the legislature, it circulated a tentative recommendation that proposed to revise hundreds of provisions throughout the codes to remove obsolete material. And some of those provisions related to judicial benefits. The commission solicited comments on the tentative recommendation and received input from several sources voicing concerns about the proposed revisions relating to judicial benefits. At that time, issues relating to judicial benefits were still under discussion amongst the stakeholders. And in light of the concerns raised, the commission removed the judicial benefit provisions from the tentative recommendation and then set them or remove them from the proposal, set them aside for future study, and has not gone back to them since. And the reason it hasn't gone back to them since is partly because of competing workload considerations, but also because there has been extensive litigation and also legislation in the interim on what are known as supplemental judicial benefits. Those are benefits that are provided to a trial court judge from a county, from the county in which the judge works, in addition to the salary and the benefits that the judge receives from the state. And the details of the legislation and the other developments relating to supplemental judicial benefits are explained in today's memo. I'm not going to repeat all of that here. For purposes of the commission's work and this study on statutes made obsolete by trial court restructuring, 2 points are really key. And the first one is that in the Sturgeon 1 case, the Court of Appeal held that supplemental judicial benefits do not violate the Lockyer-Eisenberg Trial Court Funding Act. And none of the other litigation since then has held differently. That's still good law. And the second point is that the legislature made a finding to the same effect in enacting the legislation on judicial benefits that's known as SBX 211. So with that background, I'd like to turn to the judicial benefits statutes that the commission removed from the 2001 tentative recommendation. Those are reproduced in the attachment to today's memorandum. They're grouped into 6 different categories. And today's memo discusses the first 4 categories. We'll deal with the last 2 categories in a future memorandum. So the discussion of category 1 begins on page 11 of the memorandum. That category consists of some statutes that are now in Chapter 10 of Title 8 of the Government Code. That used to be a chapter that was full of long county-specific statutes relating to municipal court districts. And much of the content of that chapter has already been cleaned out in the course of the commission's work. There are 5 articles in the chapter that now consist of basically one provision that describes a particular municipal court district, and then a second provision that relates to judicial benefits or of the municipal court judges who were in that district. So the municipal courts, of course, no longer exist. They were eliminated through trial court unification by 2001. They were all gone. Really the 5 articles that I just mentioned are only relevant with regard to benefits of former municipal court judges who served the particular districts in question. Now, for that purpose, it might not be necessary to retain the articles in the codes. One possibility would be to repeal them, subject to a savings clause that protects any rights that people may have under those articles. And there's a savings clause shown at the top of page 13 of the memo that is the same language that the commission used in its prior work on trial court restructuring for many, many other code provisions that it repealed. So that's one possibility, is just to repeal the articles subject to this savings clause. A second possibility would be what we've referred to as a belt and suspenders approach, which would be to have a sunset clause that leaves these articles in place for a certain period of time and then automatically would repeal them by a certain date in the future. And then there would also be a savings clause to protect the rights of any judge who still was collecting benefits pursuant to the statutes at the time that the sunset actually happens. So those are 2 different options, and the commission needs to decide what to do about, whether it wants to pursue one of those options, which one. I guess a third option is you could just leave these things in the code sitting there waiting for years and years and years until they're truly, truly, truly obsolete. But those are your choices. I'm interested to hear the commissioner's perspective.
Rick?
And I assume this same conversation applies to category 2, right?
Essentially, yes.
Yeah, so honestly, the savings, repealing those provisions and then putting in the savings clause seems, because the savings clause, as I read it, basically says, even though the statutes were repealed, they're still operative for, for the affected people. So that seems to me like a distinction without a difference. So I don't know what the, other than, not having the, whatever code this is, government code or something as long, I don't see what the benefit of repealing it and having a savings clause that affects it would be. Something like a sunset clause makes more sense to me,
Yeah.
but functionally, the sunset clause you want is this statute is repealed when the last former municipal court judge dies, right? And that's,
Well,
that,
I actually, I'm not,
I know you can't say that, but when
well, and I think you got to remember that they may have benefits that extend to survivors, not just to the
Okay.
judges.
Okay, so so I don't know what value a sunset clause that we don't know how long it ought to be helps either, because at some point somebody's, maybe it's something like, I mean, the only other alternative thought that occurred to me was, could the legislature, by statute, I guess, direct the judicial council to report maybe every 2 years to the legislature, every legislative session, about whether or not there is still anybody receiving these benefits in the affected counties, and presumably then, if so, if nobody's still receiving those benefits, the legislature could then make a choice to repeal the provisions affecting those particular counties. Other than that, I don't know what to, I mean, that seems like the only kind of thing that actually does what we're trying to do, is those laws stay in place until there's nobody else receiving benefits, right? I mean, that's what either of these approaches is trying to do. I don't know the length of the sunset. I think the savings clause is a distinction without a difference. So that's my other thought. Anyway.
But
No.
I want to make sure I understand what you're saying. You aren't proposing to just repeal them without a savings
No,
clause,
I'm
are you?
proposing to leave them in place. And then have the judicial council report periodically to the legislature about it, if is anybody still receiving benefits. Because I don't know what length of sunset to use. Could be 10 years, could be 20 years, could be 50 years.
Okay, but what is the problem with repealing them subject to a savings clause?
Because I think that's a distinction without a difference. I don't know what if the effect of the law is still perpetuated by the savings clause, why are you repealing the law?
I think Rick's right. I mean, as it stands, the law only applies to a certain category of people. And then if we make the change, the savings clause will continue to make it applicable only to the category of people.
Yeah, so I didn't like the savings clause idea either, but and I did like the sunset until Rick and Barbara, you guys make a good point. How do you sunset something that can go on forever? And then I'm against a special commission, and the judicial council would have a heart attack. I can absolutely tell you, they just don't have the resources. And what do you do? Do a census to see who's alive and who isn't? It's just too much. I think we don't touch it. That's what happens. So you do have this on the books. I can see from a business standpoint, it would be frustrating to have something that details benefits that may not be available to people. And then it does kind of create an expectation, but I don't know how else to get to do a savings clause that then also informs. I think you run a risk there. And then with the sunsetting, I have no idea how you can sunset it.
If we leave it as is, it functions as, and it remains a grandfather clause. It only applies to the people who are grandfathered in.
Right.
It
And I
doesn't
think
apply to anybody new. And then,
Because
it'll naturally evaporate when that category of people shuffles off.
Yeah. That's what I think you do.
Okay, well, the commission is responsible for cleaning up the codes to reflect trial court restructuring. The advantage I see of the repealing it with subject to a savings clause is that then the codes are cleaned up, and the savings clause protects the rights that are granted to the judges by the provision that is repealed.
What have we cleaned up? The provisions are still there. We've just added something to them. So if anything, we're adding, not taking away.
No, they're taken out of the codes.
And I
It's
think
just-
it creates an issue too, Barbara, that you might not be anticipating. If you were a beneficiary and it's removed and it was confusing to a layperson to understand what your rights were, then you're going to create liability that was unanticipated. So then you have the unexpected or unintended consequence of creating confusion when none needed to exist. So that's not cleaning up anything. It
And-
sounds cleaner, but in terms of benefits, it's not cleaner.
And it seems to me cleaning up means remove things that no longer have any effect or affect anybody because there's no more muni courts. Well, there are muni court judges who are getting benefits. So I could certainly make a case that this isn't a non-substantive cleanup. This
Exactly.
is something that still affects people who are receiving these benefits.
Jane, but you have to unmute.
I'm unmuting. Could this be addressed? Could we just leave the section in and address this in a comment that describes the process of why it's being left in, and that the commission's understanding is that eventually it will be sunsetted out? I mean, I like the thinking along the lines of it's a grandfathered issue. I mean, is that something that would address the concern about the cleanup, but also not end up destroying any possible application to people who might come along? I mean,
I think the comment would work if we had an assignment or a charge to clean up the benefits provisions specifically, but we don't. It's to clean up the statute. So I don't see, we've left some in, Barbara, for the, when removing it was going to
We
create an
have.
issue. Yeah, this is one we need to leave
We
alone.
have left things in the past. We also have repealed a lot of things subject to a savings clause. I guess another alternative to, what Rick was describing might be more palatable to an entity like the Judicial Council, or perhaps it would be CalPERS. I'm not sure which entity would be the right one.
CalPERS
But-
could do it,
But
and they probably have.
instead of directing an entity to check in every couple of years, you could set a date far in the future, like 20 years down the road or 30 years down the road, and just say, in that year, the Judicial Council shall report to the legislature on whether there anybody left using the benefits pursuant to X statute.
I like that, honestly. And CalPERS would do that because part of their management of benefits is to do a census. So they probably.
I'm not sure that
could do-
CalPERS is in charge of all of the benefits that would be involved here. Some of it might come from other entities. I'm not an expert on benefits law, I'm afraid.
Yeah. Anyway,
I think there's a judicial retirement system that by statute is administered by CalPERS.
JRS.
Well,
It's called
that's
JRS.
true, but that's the state retirement system, and we're talking about these, in some
Counties
instances
too.
about the
Yeah.
supplemental county.
yeah, because
or-
LA County would have something too. But I mean, I just think that but we don't even have to manage each county. And I think that it would be a matter of local. I think if you did something like that, we could do a sunset, and it would be easy if we set it out to like 2032. That's probably not a bad idea.
Brian
I mean,
wants.
The thing is that all that we're doing here is purging deadwood. Okay, so there's statutes that had relevance when they have relevance while there are people who receive benefits they earned while being municipal court judges. Eventually, those statutes will all be completely obsolete. We just don't know when,
Right.
because we aren't in a position to sort of canvass the former muni judges to see who's still drawing benefits or their heirs or
Yeah.
whoever, successors. So the idea was, we know this stuff's going to be obsolete someday. Let's purge it out now, either immediately or at some specified date in the future, with a savings clause to make sure nobody loses their rights as a consequence of the repeal. Now, the savings clause does not have to be codified. It could be codified, but it doesn't have to be. We could make it an uncodified provision in a bill. So we wouldn't be adding to the burden of the codes necessarily, but we would be taking this stuff off the books, because we know that eventually it's going to be dead letter. So that's the whole idea. The sunset as opposed to immediate repeal, I think the notion is that there's some value to having this stuff on the books while people are still administering it.
I think so.
And so we don't know that it's completely dead yet. So leave it on the books for 20 years, 30 years before it goes away, on the presumption that it should be dead by then. And we don't have to revisit it. Nobody has to do any kind of future reporting. And you can make it 100 years, but that's absurd. But you could make it a significant amount of time to where you're pretty confident that'll be it. It'll be dead. But you can't be 100% confident. So you throw the savings clause in to make sure that some people still have their existing legal rights. That's the whole issue. The alternative is somebody comes back and looks at it again later. And that's what we were trying to avoid, is having an obligation to come back in 20 years or whatever and look at it again. So that's just, in other words, what you have been talking about, but just trying to present it in a slightly different light.
I think sunsetting is good, because then what you would do for, if you are managing a benefit program, then what you would do is grandfather in existing recipients or beneficiaries onto new benefit plans. So if, at least if you put a sunset date in there, then people would all be aware, no matter the jurisdiction, and they would figure out that they can't just leave it alone forever. They need to go ahead and at least plan out. And usually they do plan out like 5 to 10 years anyway, when they're doing, when they review plans. So I don't see there being, sunsetting is probably not a bad idea.
So, Brian, you're saying leave the statute on the books, add a long sunset date, and put a savings clause in there too, as a.
Yeah, that's what Barbara proposed as the belt and suspenders approach in her memo. So, 20 years from now, it gets purged out of the codes. It's not sitting there being dead letter, but there's also this backstop, just in case there's still some people drawing benefits under those statutes, their rights wouldn't be abrogated by the repeal.
You could even use a super long sunset, like 50 years, and
Yeah.
that would account, I think, for any survivor who was young at the time. I mean, if a judge had married someone who was really young when they got married, or had a child who was one of their survivors.
Yeah.
I think 50 years would probably be safe, though.
Sounds like a law school exam question.
Yeah, I have to say, like, any amount of time that we put on there is totally arbitrary. We're just guessing.
Yep.
So I don't know. I'm still with Rick. I don't buy the sunset clause, savings clause, leave it on the books. Like,
Well, the other option would be to purge it immediately and put a savings clause on. If the goal is just to get out of the codes language that we know is eventually going to be dead letter, and may even be now.
But we don't know. We don't know. I agree with you. It might be dead now, but we have no idea if or when it will be.
And I
Well,
don't
we
like,
know it will be. People
Eventually.
die.
Jane?
We can at least agree that people will die.
So another thing we could do, which would Kristen and her folks would curse us for, is we could kick it down the road and just say, commission doesn't consider it ripe for action yet. Revisit it ourselves in 20 years.
That's a
when
good
none of
use
us
of an
will have to
arbitrary
worry
number.
about it.
And Kristen pops right on.
I know. She was like, wait a minute. Jane wanted to say something. No? Okay.
No, I did. I mean, I did originally. So I was listening to Brian. I was thinking the same thing. So, I guess we keep arguing around it, but the fact of the matter is, of course, we don't know. So isn't the most effective way to deal with it? And I mean, deal with it in a definitive way so that we don't have to keep coming back to revisit it, or that's like the hanging chad, right, out there forever, is if you put an extra long sunset provision with a savings clause, then no matter what, it's covered. So then you just can move on. I mean, I'll be honest, that's my inclination. That's how I think I would like to deal with it, just because I think that then we don't have to run the risk of having, run any risk, frankly, because we've covered it all around, is the way I'm interpreting that.
And we don't kick the can down the road for somebody else to deal
Yeah,
with later.
we're on this study. We need to finish it. We need to be done with it and in a definitive way, and not worry about what's going to come back or change. If we've covered every eventuality by those two mechanisms, it seems to me that there's no downside to doing it. It's not like but that's what would be how I would vote on that one.
I think 20 years is actually not that bad. That's a good amount of time. So,
Well, let's not put the cart before the horse. Time aside, what about the concept? Belt and suspenders concept, sunset.
I like the concept because I do think it protects, I'm not the only employment lawyer, but I do, I'll go ahead and use my expertise. But I think that, I would protect, I would want it to be on the books so that people can understand it. But I also want it, I like a sunset. That was my initial inclination, but having both the savings and the sunset should do it. Rick?
Okay, I will move a belt and suspenders with a 50-year sunset, as Barbara said. Because I think that makes the savings clause irrelevant, but.
I don't think the 50 years, honestly, the 50 years is not necessary because, but it's fine because you're planning ahead. Yeah, that's fine. 50 years will do it, but I don't think you have to. 20 years is practical.
I think it's academic. I mean, because we have the savings clause. So if 50 years makes it look like you're protecting any potential eventual, I mean, I'll support that. I would second that motion that Rick just put forward, because I think I don't think we have to parse the number of years at this point. Just make it sufficiently large, and then you've got your savings clause, and then we can just move on.
Okay. All those in favor? Looks like, okay. So it's all, just when you record it, Brian, if you do, I'm going to say nay, or to, why am I saying that? I like, yeah.
I can tell you.
No, I just think that it is probably more helpful if we make it within a 20-year revisit clause, because I think it allows a Kristen to chime in and say, okay, that's what they were thinking, as opposed to who knows what will happen in 50 years. I think that looks like we didn't want to deal with it, but that's okay.
Okay, so one no vote. And Barbara, note that Commissioner Rubin is not present.
Yeah, I've got that. And so I understand the vote. Did you agree on the 50 years, or did you just agree on the approach without specifying the 50 years?
We're all in
was
agreement
50
with the
years.
approach.
50 years with the savings clause.
Yeah,
50 years with a savings clause, and Commissioner Miller O'Brien says no, because you would prefer a different approach, and which I understand also.
Okay.
Okay. One refinement of that then perhaps. On page 13 of the memo is the language of the savings clause. which says, or proposed savings clause. It's the language that the commission has used before in this study for quite a number of provisions. If a right, privilege, duty, authority, or status, including but not limited to a qualification for office, etc., is based on a provision of law repealed by this act, and then it goes on. And I think we should add some language that says, or repealed pursuant to a sunset provision enacted by this act. And I think we should add a similar sort of language at the end of the savings clause, just to make absolutely explicit that it's covering not just a repeal that happens automatically, at the time that the commission's proposed bill is introduced and enacted, but also the repeal that happens pursuant to the sunset clause.
Honestly, I don't think you need to. A sunset is a repeal. So I think.
It's a repeal, but is it a repeal by this act, which would be the
Yes.
act that puts the sunset clause in place?
Right. This act repeals it effective on the date that the sunset clause specifies. In fact, your savings clause or status continues for a period beyond the effective date of the repeal. So I don't think you need to. I mean, it's kind of,
I like it.
And I think that that's probably right, that it's implicit in the language that's already there on page 13.
Right.
I'm just raising the possibility of making it express.
Yeah, I like it expressed, and you're coming from a standpoint of somebody who's well-versed in this area. So we have to make it layperson friendly as well. And then people who are administering benefits. So I like the signposts of just helping to make sure that it's clarified. So
But there is a downside, a potential downside to making it express, which is, somebody might complain that the lack of similar language in their savings clause, you could draw an implication from that maybe that means the sunset clause isn't covered. So I am not certain it's a good idea to make it express.
Let me add just a couple of points. One is in terms of drafting, and we could figure this out later. I don't know that a reference to a sunset clause would be precise enough, because that's a sort of a colloquialism to call it a sunset clause. So you might have to get much more specific. The other thing I wanted to say is, to the extent that this is a question of intent, maybe we could address it in the comment. Use our standard, and this avoids any implication from having different savings clause language in different provisions. We could use our standard savings clause language and just put a comment on it that says, that the repeal pursuant to this act includes repeals that are deferred by the language of this act. See, for example, sections blank, 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 blank.
Mm-hmm.
That sounds good to
take
me.
care of it. Yeah. Good.
Sort of split the baby.
Yeah. All right, Barbara. Barbara, everyone's in agreement.
Everyone's in agreement with using the comment approach?
Yes.
Okay. So that takes care of category 1 in the memo. Category 2, we start on page 13 of the memo. It consists of only one provision. This is section 77210, which is also a provision that pertains to retirement or benefits of municipal court judges. These are ones who retired under the judges' retirement system. And since all of
Can I interrupt you though? I'm just looking at the time. So it's 12 and I know they're waiting for the emergency.
Okay.
So we just, well, no, maybe we just finish this. I think
we can finish up the memo very quickly.
Okay.
So this provision is really pretty much on all fours with the analysis that we just discussed. Would I hear a motion to treat it the same way?
Yes. So moved.
Okay, I'll second it. We're all in agreement? Aye. Okay.
I'm
that's
not
a-
sure if Commissioner Carrillo is present for this vote.
Oh, are you there, David?
I think he stepped out.
Left. Okay.
Okay, so no, he's abstain
And we have a quorum. so-
or not present. And then the next category is the one that involves the two provisions that relate to supplemental judicial benefits in San Diego County and Riverside County. And the staff recommendation on those is to leave those alone because they have been, is that something people are comfortable with, given the analysis in the memo?
Yes.
Yes. You got 4. We're good.
Everybody agrees on that?
Victor, you're okay? Yeah.
Yep.
Okay.
Okay, leave alone. And then the last provision is one that involves judicial benefits, but also involves court reporter compensation, which is a topic we have chosen to defer. And I think any attempt to make revisions in this would get bogged down in court reporter compensation fights. So the staff recommendation is not to do anything with this one until you're ready to deal with court reporter compensation. Is that acceptable?
Yep.
Yes.
Okay, that's the end of the memo.
Good job. Thank you, Barbara. Sorry to rush you on that.
That was fine.
All right, guys. Thank you attendees for hanging in there. Now we're ready to go ahead and work on the last agenda item, which is number 6, X100. Brian.
Yeah, this is Memorandum 2064 and its first supplement. This is the common interest development meetings by teleconference during emergencies. And we had a tentative recommendation on that. It went out for comment. The comment deadline has passed. We did receive some comment, which is collected in the attached to the first memo. The comment was all favorable. We haven't heard a single negative comment about this, the overall concept of this proposal, nor has there been any comment that anything in the tentative recommendation was problematic. What we did get was comments suggesting ways to improve the proposal. But considering that the support was universal and there were no objections to the specific elements of the proposal, I went ahead and prepared a draft recommendation. So it's attached to the memo as well. And once we've worked our way through the suggestions for possible improvement, the commission may be in a position where it's ready to approve a final recommendation with or without changes based on the specific items I'm about to discuss. So what I'm going to do is just move through the suggestions for improvement in the order they're presented in the memo, and then we'll circle back and see whether we're ready to make the big decision on approving a final. We received a letter from Kazuko Artis. She lives in a CID in San Francisco. She's been a regular commenter to the commission in its work on CIDs. And she has a few different issues that she wanted to raise. One of them had to do with the location of the proposed law. As it was drafted, the proposed law created a new article in the Davis-Sterling Common Interest Development Act titled Emergency Powers and Procedures. And this new provision on meetings would be located within that article. And the commission decided on that approach because it anticipated that it's conceivable there might be future provisions of this type, emergency-related procedural rules, that might be added to the Davis-Sterling Act, and so it might make sense to make a container for them. Ms. Artis thinks that people might overlook it there and suggests that it instead be co-located with the existing provisions on meetings. Now, there's two kinds of meetings. There's board meetings, there's member meetings. Each one of them has its own article. And this section applies to both. So you can't, you would have to choose where to put it. You might create a separate container next to them that applies to all meetings, etc. My suggestion in the memo is that we keep the existing location and consider the possibility of adding a cross-reference to help people know about this. So existing section 4090 is the definition of board meeting, and that's the provision that contains this problematic provision that we're circumventing in this proposal, that there be a physical location when you teleconference. So the language I set out on page 2 of the memo, in subdivision B of 4090, about halfway down in that subdivision, it currently says, except for a meeting that will be held solely in executive session, the notice of teleconference meeting shall identify at least one physical location, etc. And I propose saying, except for a meeting that will be held solely in executive session or conducted under section 5450, blah, blah, blah. So the place where the law requires this, there would be this cross-reference to say, hey, go look over there, there's an exception to this rule. And I actually think that that might be a more instructive way to handle this that wouldn't require us to relocate the proposed section. Is everyone okay with that? And members of the audience, if anybody disagrees on any of these points as I cover them, raise your hand so we'll know that there's somebody who wants to speak to it. The next issue has to do with the application of the proposed law. And there were two comments on the application of the proposed law. The first one for Mr. Grossman was one we've heard before, which is don't limit this to emergencies, make it the rule always. And the commission specifically decided against that prior to releasing its tentative recommendation. And Mr. Grossman hasn't offered any new argument that we hadn't heard before on this issue. So my inclination would be to reject that suggestion. The reason being, the main reason being is prudential. There is value in having a proposal that's limited to emergencies, because the legislature will look at it through that lens and think, okay, fine, we can live with this in emergencies. If we broaden it to apply to all situations, including non-emergencies, then you're liable to get more opposition from people who are saying, no, stick to the existing rules in non-emergencies. Those are proper, they were enacted for a reason, etc. So we're trying to keep this clean and not tangle it up with changes that might draw opposition, because the goal was a quick fix. Now, that said, I see Linda Brown has raised her hand. Chair, is it a good time to allow her to speak to this issue?
Yes, please.
Okay, I'm allowing her to talk. Linda, if you unmute, you will be heard.
Hi,
Thank you
Linda.
very much. I would like to also recommend that it be an option for all meetings, and I'll give you an example. We just had our annual meeting in a 60-unit condominium. There were 22 of 60 people attending via Zoom. That's 36%. Going through historical records, we typically had 12 over 60. That's our 20%. That's a 16% increase. In addition, my 3-building complex, in one building, it's unfortunately gone very much to renter occupied, more than 50%. I think it's about 64%. So you have people that cannot physically come to a meeting, plus out of our board, only 1 of 5 lives in the 3-building complex. So I would strongly suggest that Zoom meetings be an option, be allowed for all meetings. It was great to see new people get involved. I've been an owner over 40 years. It's the only way, I share ownership with my sister who lives there. And it's the only way I would get to know some of these people because we don't have a common meeting area. We have 3 buildings. It's really important that we make this an option, and people are learning to use it. Thank you very much for giving me that opportunity.
So let me add one point, which is that existing law already permits teleconferencing for CID meetings. It just requires that there also be at least one physical location where a board member is present. So if you had an I don't doubt that teleconferencing, as people get used to it especially, is increasing participation at meetings. We're seeing it in our own. We're getting much more audience participation than we used to when people had to travel to Sacramento and set aside an entire day to sit in the hearing room. But there's nothing that precludes that from happening. The only thing is that we're doing is we're waiving the requirement that there be a physical anchor site, because the special circumstances of an emergency might make that impractical.
Okay.
And we have heard testimony on the other side that absent the emergency justification for doing away with that, they like it. Because it requires them to accommodate people who don't want to do Zoom, who want to participate in person. And so existing law requires associations to permit both, whereas if we excuse them from one, they might do all their meetings on Zoom and somehow, as a consequence, disenfranchise those who aren't technically savvy or don't want to or aren't able to participate electronically.
I hear you on that, and I think that could work in our particular 3-building complex. We don't have a common meeting room. We only have gates to get entered into. So someone has to go somewhere,
Right.
Which in this case is a mile away to the property manager's office.
Well, that's the second issue on application, is associations with no meeting space, but let's hold off on that for a second.
Okay.
Just see, what do commissioners think about leaving the proposal the way it is in terms of limiting it to emergencies rather than generalizing it to all meetings?
Are we
Does
all in
anyone-
agreement that it should stay the same?
Does any commissioner want to
Emergency
change it?
only? No.
Okay, then no actions required because that's the rule in the proposed law. So the second issue on application was the one Ms. Brown was just talking about. We received letters from Adrian Adams, CID attorney, and from the California Association of Community Managers in the first supplement, both pointing out that there are associations that don't have a meeting room. And so if they're going to hold meetings, they either have to sit outside on somebody's patio, go into somebody's apartment, rent a meeting room somewhere, etc. So they are suggesting that in addition to applying during emergencies, this rule also ought to apply to associations that do not have within the CID meeting space.
Yeah.
Now I see a lot of merit to that. It makes some sense, good sense, I think. But again, there is this, I am inclined to hold the line on the content of this proposal so that we can give the legislature an emergency related reform. This would, and say, because it might be also that it would make sense to ask the legislature to enact that reform on an urgency basis, so that it takes immediate effect when signed by the governor rather than waiting until the beginning of next year, because I think that these issues are ongoing and it might be helpful to get this fix in place sooner rather than later. And it would be harder to justify that urgency if the reform were addressing non-emergency related matters. So my inclination, my recommendation would be that we not change this proposal to address the associations without meeting space, but bring it back once we see whether the legislature has appetite for this. So put our bill in, see if they enact it. If they do, then we can start looking at the substance of whether to expand it. But I just don't want to burden this proposal unnecessarily.
I agree. Is
Any
everyone in
commissioner-
favor? Yeah, keeping it emergency, yeah.
Okay.
And then Linda, I think as we learn this with this new normal, I mean, who knows if we're maybe after a year, we're gonna learn some other new issues come up with, Zoom meetings. So I think it's a good approach. It's methodical, and then it would also help to secure any type of permanent resolution if it was something that we would need to do, assuming a member didn't pick it up and push it to the legislature on their own.
Okay, so Ms. Brown, I'm going to put you
Okay.
back in the audience so that we can proceed to the next issue. And if you want to be heard again on any further issues, you can raise your hand and we'll activate you. So the next one, again, from Ms. Artis, she suggests requiring associations to offer toll-free telephone dial-in numbers. And, as I say in the memo, it's not toll-free in the absolute sense, it's toll-free to the people who are dialing in. And the cost would be shifted to the association, which, they're probably better to bear those costs, but they may not be trivial. I checked, and our provider, Zoom, charges a minimum of $100 a month to have toll-free numbers. And if you're an association smaller, as I said, half of the associations have 25 or fewer units. If you're an association with 10 units and everybody's local, why should the law require you to spend $100 every meeting just to make sure that people can call in toll-free when nobody's going to do that? I think that this might be an issue that's better left to the democratic processes within the association itself. If there are enough members who want the association to provide this service and bear the cost collectively, they can ask their directors to do that. And, hopefully people will be reasonable and work it out. I know that CIDs do not have a reputation for reasonable accommodation, but I am reluctant to have the law mandate that all associations bear this cost. Does the commission see it differently? Okay.
No.
I think this is, another point raised by Ms. Artis is, she and I have heard that a lot of associations have been holding teleconference meetings by Zoom without a physical anchor, even though the law doesn't allow you to do that. Because, they're doing their best. They don't want to aggregate. They have to hold meetings. So they're just doing it. Or maybe they don't even know that the law requires the physical location. She wonders whether that exposes the decisions made at those meetings to challenge. If somebody doesn't like a decision made at one of those meetings, you could sue and say, hey, that wasn't a lawful meeting. That's not a valid decision. I think that risk exists. She suggests a couple of possibilities to address it. One is post hoc ratification. So yeah, we made those decisions. Yeah, the meeting wasn't valid, but we now vote at a lawful meeting to reapprove them and ratify those decisions. And she suggests the law permit that. I say in the memo, I think the law already permits that. There's nothing to stop any body from saying, we now decide the thing that we sort of decided before, and that is now our present decision. And if it's lawful, then you have just approved it. The other suggestion she makes is that there be some kind of safe harbor in the law, that it just say all the decisions made at those any invalid meetings during the COVID-19 emergency prior to enactment of this new law, those are all lawful. We could do that, but I'm disinclined, partly because I think ratification is a good option that's available, and also because I think that would sweep perhaps too broadly. There might be actions that shouldn't be valid and should be challenged. Maybe the association used Zoom and didn't tell anybody so that nobody had a chance to participate. It's like, how would we parse this savings clause to differentiate between the ones that should be saved and those that should not? And I also think there might be a constitutional issue that I would need to research more in terms of a statute retroactively invalidating procedural requirements that the association has in place for its decision-making when those procedures are tied to people's property interests and the decisions under them might have affected their property interests. So there are constitutional limitations on the ability of a statute to retroactively divest someone of vested property rights. And I worry that the legislature after the fact saying, yeah, you know, all those procedural rules you guys chose for you to govern your property rights, we're saying that we're going to override those retroactively. So I worry that if we tried to do that, we'd just people would wind up in court anyway, and it would be a mess. And I think the cleaner solution is the ratification. They could just pass a motion to approve all of their decisions from the prior 6 meetings. So I recommend against doing anything on that issue. Does any commissioner see it differently?
Yeah, we're all in agreement.
Okay.
Yeah, leave it alone.
Ms. Artis also, I think this is the last one, suggested that we add an enforcement provision for the statute. She points out that there are in the Davis-Sterling Act existing enforcement provisions like section 4955, which I block quoted on page 6. A member of an association may bring a civil action for declaratory or equitable relief for a violation of this article by the association, including but not limited to injunctive relief, restitution, or a combination thereof, within 1 year of the date the cause of action accrues. And then the subdivision B is fee shifting and penalties for an association that is found to have violated the requirements of the article. This is the article that governs board meetings. So there is an existing provision that allows you members to sue for a violation of the board meeting rules. And Ms. Artis is suggesting that there ought to be existing enforcement mechanism for the provision we're creating, which says you can do a teleconference with no physical anchor provided you meet certain requirements. Well, they didn't meet those requirements. Should the members have express authority to sue them for that violation, similar to 4955? You know, as I point out, one of the reasons this is an issue at all is because this substantive requirement of the physical anchor was stuck into a definition provision, which is not within the article that's governed by this enforcement rule. You know, that was probably a mistake at the time. They probably should not have put that substantive rule into the definition. They probably should have put it into the article that's governed by this enforcement rule. So, you know, someday further down the line, it might make sense for us to look at moving that provision into the article that it applies to so that it's subject to the existing rules on enforcement. But I'm not inclined to burden this proposal with a new enforcement provision. I think that's likely to be controversial. You know, there are a lot of, this is the law. And so clearly there's some appetite for having this kind of provision, but it does add costs. It invites litigation where maybe people could work things out otherwise if they weren't going to sue over it. And so I do think that right now we have a proposal that I don't think is going to draw any opposition, and we could maybe get it through really easily with the supermajority that's required for urgency legislation. If we put in something that some of the interest groups in this arena oppose because they think, oh, now we're going to get sued about this too, and this is going to add costs and increase our insurance costs or whatever. I see a likelihood that that's going to draw opposition, and so we won't have a clean bill. We'll have a bill that's going to have to be heard in every committee rather than being on consent, and the parties might split on it or whatever.
Yeah,
So
Jane,
my inclination is let's put this on the list of possible things to revisit more broadly about whether this teleconference rule ought to be in the article on board meetings so that it's subject to the existing enforcement mechanism. But I don't want to add one just for this one section.
I was just going to say, I agree with that. I think the problem is that we almost changed the nature of the provision, because someone might interpret that as basically being a strict liability issue, where if they violate the provisions, they're automatically
Entitled to.
entitled to relief. And so I would really veer away from that. I think it's unnecessary, and I also think it might be interpreted in a way that changes the legislative intent of trying to do that.
Rick?
Yeah, I would concur. I think Brian's admonition about having getting legislation that we can deal with the pandemic and some of the particular circumstances that are necessitated by the pandemic and get that done quickly is important. In the legislature, it's hard to make an argument against a bill because of something it doesn't do. You can make an argument against a bill because of what it does, but it's hard to argue that a bill shouldn't be passed because of what it doesn't do. It doesn't do lots of things.
That's a good point.
So I concur with Brian, and actually would marry that with recommending approval or moving approval of the tentative recommendation, the draft recommendation.
Yeah.
Yeah, that's where we are. There's, we're done with the
Second the motion.
suggestions for improvement. Okay,
Yeah, I think you have what you need to move forward with that.
I'd like a actual vote, though.
Okay.
We have a motion and a second.
Mhm.
You have the consensus. You want, yeah, so it's a full, Victor, are you in agreement? Okay, you have a
Okay,
full.
so all aye votes with Commissioner Rubin absent. Okay, that's all I have on that. And
Okay.
that's the last item on the agenda.
You guys, thank you. We won't see each other, but happy Thanksgiving. You guys
yeah.
be safe.
Good work, everybody.
Ms. Brown put her hand up. I don't know whether she wants to add something. I'll activate her and there you go.
Yes, sorry, I could not keep up with all the paper documents. Did I see that you have a recommendation that CID is not a real big priority for next year?
When we were working on our priorities for next year, yes, we decided against a broad study of miscellaneous CID issues. I do think once this bill is done, we could consider coming back and studying issues related to teleconferencing that aren't emergency related. But we don't otherwise intend to do any CID work next year.
Well, I would ask you to reconsider that. And again, based on my over 40 years experience, and assuming, let's see, it's understanding there's 52,000 CIDs, and let's take a very low estimate of 100 units. If there's only 0.1%, that's 52,000 people that might be losing their health, home, and life savings because of litigation, because there's not proper education and training for board members, let alone people that buy into a condominium. And for example, we've had, unfortunately, a series of very poor property managers. We now have a good property managers, as well as an involved board that has complementary and high-level skills. They have figured out our next special assessment is going to be $23,000 unless they can figure out how to lower it. Part of that is a fire prevention mandate. That's 1.38 million for our 60 owners, on top of about $25,000 of special assessments that started about year 2000. You know, most middle-class people can't afford those kind of costs. And I would really like to work with you on ways, on more transparencies and better communications that I think could be addressed by the laws. So thank you for considering that. And if I'll try to get something to you in writing separately.
I think that's good. And then in January, I think we're going to see just a tide of changes just because we're still stuck in the pandemic longer than anybody anticipated. There might be lifting of moratoriums. There might be a lot of other issues, but we welcome you back. We'd be thrilled to have you come back. Write your letter so we can look at it. And in the meantime, you guys all be well. I'm just sticking close to consideration.
Let me interrupt you, Chair. We have a few minutes left, and Catalina Sanchez has her hand up, and we haven't heard from her before, so I'd be interested to hear what she wants to say.
Ms. Sanchez? Are you gonna let her?
There you go. You need to unmute. There you go.
Oh, hello, commissioners. Thank you so much for the time. Yeah, this was my first time attending this meeting, and I wasn't sure what the proper layout was for me to make a public comment on an agenda item. Would that be now?
What did you want to speak to?
The interstate reciprocity
Oh, okay.
item.
Well,
Would
let me
it be-
say the commission's decision was that we are going to be requesting authority from the legislature to study that. Brought with it, and the language we'll use is the language that was in the memo. It would be broad, unconstrained language. And did you want to weigh in on sort of whether that makes sense, or talk to some other aspect of the issue?
Yeah, I mean, it would be just a recommendation. As you know, obviously, I know that this would still have to go through the legislature as a concurrent resolution. And I don't know if my comment is maybe premature, since it would be more for when the commission decides to assess and study this issue after
You know what,
passage.
if you know what, I'm thrilled that you did have that comment, and next time, just, let us know if we're on that agenda item, definitely just jump in, but
Yeah.
at this point, we're gonna go ahead and see if we have the authority to study it, and then we would welcome you back, because we're gonna need a lot of help from stakeholders like you.
Let me suggest this. You could certainly weigh in during the legislative process when they consider the resolution. But I would ask that you go to the website, find my email address in the personnel part of our website, and send me a note, and we can talk. And I do want to hear what your thoughts are on this, and we can take them into account as this moves forward.
Yeah, and then if I could just note for the record, I know there were a couple other stakeholders that did want to make comment, but again, we weren't sure when the appropriate time was for that. And I know one individual did get a chance to speak to the issue
Yeah,
earlier. Yeah.
yeah. If you know who those people are, extend the same invitation I just made to you. That reach out to me. I'd be happy to talk to anybody about this.
All right, great. Thank you so much, Commissioner, and all. Of course, thank you so
Have a good
much.
day.
Yep.
You too.
All right, and
Any other further comments, you guys? You're good? All right, bye, everyone. Thanks for hanging in there.
Happy Thanksgiving, everybody.
No, thank you. Happy Thanksgiving, guys. Talk to you later.
for adjusted to circumstances.